us esteemed assistant professor at India International University of Legal Education and Research, Goa. Introduction of speaker. Ms. Sinha ma'am holds a master's in criminal law from National Law Institute, University, Bhopal, and has a qualified the UGC NET. Her areas of specialization include criminal laws, human trafficking laws, and film certification laws. Ms. Sinha's impressive academic journey includes notable position at the North Cap University and Ramai College of Law. Her extensive research has been published in prestigious journal and book, focusing on contemporary legal issues such as online content, censorship, and abusive language in web series. She has presented her work at both national and international conferences, receiving accolades for her contributions, including the Best Paper Presentation Award. Through her participation in various workshops, Ms. Sinha ma'am continually refines her teaching methodologies, ensuring an enriching learning experience for her student. Her dedication to advancing legal scholarships and pedagogy establishes her as a respected figure in the legal community. So, without further add-on, let's welcome Ms. Nidhi ma'am. Ms. Nidhi ma'am, the platform is all yours. Please enlighten us with your session. Over to you, ma'am. I think ma'am mic is muted. Ma'am, you need to unmute yourself.
Yes, I actually wasn't getting the permission to mute. That's why I requested to mute. So thank you so much, Divyansh, and thank you to CPJ College for having me here. Um, I'm Dr. Nidhi. Thank you, Divyansh, for the introduction. I'll just add a few things to what Divyansh has already said. My doctorate is from National Law School, Bangalore. Thankfully, I've been able to recently complete my doctorate and uh, have been very fortunate to work with ILR Goa for a year. And I was working there till December. And from January, I've opened my own company, my own firm, and I'm working with that. So just in addition to what you have already said, Divyansh, thank you so much. In today's session, we'll be talking about the second module. Please allow me to share my PPT. And please let me know if the PPT is visible to you guys.
Yes, ma'am, it's visible.
Yes. Okay. I'd like to begin the slideshow also. So after that, if you can see, please let me know. Is the slide visible?
Good evening, ma'am. Dr. Shweta this side.
Evening,
Due to
doctor.
some problem, I'm not able to on my camera. And I'm requesting that please introduce the students and faculty members about your legal research writing firm that you newly established, as we can aware about your activities and opportunities that we can avail in future. Please, ma'am.
Sure. Thank you, ma'am. So this firm basically helps research scholars, legal scholars to write papers, to write thesis, to write dissertation. So the concept is that if you are thinking of writing a research paper, or if you are writing a research paper and you're stuck somewhere, you are not really sure how to do research, you're not really sure if I should go ahead with this research, and you need any kind of guidance, this firm helps you. So our purpose is to ensure that if you have started your research, you complete it, and you don't face any hurdles while you are writing this research paper. You get to publish it in a good journal. You don't compromise on the quality of the journal, because at some stages you face any kind of hurdles, or at some stages, you're facing a rejection from a good journal. So you should be able to accept that, okay, there are changes required, and then you should seek guidance and as to where should I make those changes. So any kind of problem that a research scholar, a law student faces while doing his research, while writing, our focus mainly is on publications, because you have to, if you have to survive in this legal industry, nowadays you cannot do it without having good publications. So to ensure that students have good publications, whoever are willing to research, we work with this firm. So that's Upkritam Legal all about.
Thank you very much, ma'am. Highly blessed.
If there is any disturbance in my voice or in the audio, please let me know, because only from your interruption will I come to know if there is any disturbance from my end. Otherwise, I'll begin with my session.
Yes, ma'am, please.
Thank you. So, students, today we are going to talk about this concept, the module 2, which covers the essential components of crime. What is actus reus? What is mens rea? How do you determine whether somebody is culpable, somebody is guilty in criminal law or not? How do you determine what are the standards on which you hold someone liable? Once you hold them liable, where will you try it? Who will try it? So we talk about jurisdiction. And once all of this is done, we talk about what happens once you've been held guilty. So the concept of punishment comes in. When do you punish? How do you punish? How do you determine what is the right kind of punishment? And then on what basis do you justify as a judge? How do you justify that this is the right punishment that I'm giving? So these principles is what module 2 focuses upon. Right at the outset, please understand that when IPC was converted into BNS, when we had BNS, that is like from yesterday, it got enforced, the essential principles of criminal law haven't changed. We still work on the same principles. We still work on what constitutes the main components of crime. That hasn't changed. So in these specific concepts that we are covering in this module, you will majorly see only changes in terms of provisions. Like if something was being mentioned in section 8 somewhere, now it's mentioned somewhere else. So this is the major change that we see here. Apart from that, I'm sure in yesterday's class also you had a brief discussion on one aspect of punishment that is being added here, that is community service. So we're going to deal with that also, but we're going to go step by step and understand, right? So I'll request you to keep the chat box also open, because today it's not just going to be a one-way communication. We're going to talk and we're going to discuss a lot of things. I'm going to ask you questions. So when I'm taking a slide, once I've done it, you can ask questions in the chat box. And once you have asked questions, I'll start asking questions. I'll give you situations and you'll have to solve it. So stay glued, stay attentive, because you'll have to answer questions throughout the session. Okay, so let's start with questions only. How many of you have already learned criminal law basics? Just give me a hands up. Just give me a hand raise of how many of you have learned the basics of criminal law. So I'll have an idea of where would you be in terms of your concepts. Okay, if Divyansh or Shweta ma'am can tell me about the audience, if they are well versed with the criminal law, if they've read basics, in what year they guys are. Rahulji, if you are able to hear me.
Ma'am, I didn't heard.
Yes, sorry, I couldn't hear.
Ma'am, please pardon.
I'm saying, in which year are you all, the students usually, what is the kind of...
Usually they are from 3rd and 4th years.
Okay,
and
so
some
they
are
have
from
read
2nd year
criminal
also.
law, right?
Yeah.
Okay, all right. So I think I can ask them basic questions. So, all right, let's get back to the slide. Just is the PPT visible to everyone?
Yes, ma'am, it's visible.
Okay. So before we begin, let me quickly ask you people, how much do you know about criminal law? So let me ask you, what are the essential components? What are the two factors which make up crime? So you can put the answer in the chat box. You can quickly message me that these are the two components that make up crime. What are the two main essentials of a crime? Anyone? You can put your hands down, the ones who have raised hands. Thank you. You can put your hands down and you can, if you know the answer, quickly write it in the chat box. What are the two things that make up a crime? You can see the chat box. You can mention it here. There are two things that make a crime. It's very important that these two factors need to be present for anything to be called a crime. What are those two things? Anyone? Okay, so I might just randomly pick up somebody and ask. Is Sujata here? Sujata, can you hear me?
Yes, ma'am.
Can you tell me what are those two things that make up a crime?
Actus rea, mens rea, and injury.
Actus reus,
Mens rea
mens rea,
and
and
injuries.
injuries. Very good, very good. So, can anyone tell me what is the Latin maxim? Anyone? You can just unmute yourself and tell me what is the maxim that states that there are two essentials to a crime.
मैम एक्सेस नॉन स्पेसिफिक क्रिया मिसिंग नैन की क्रिया का मतलब है कि कोई भी ऑफेंस जब तक क्रिमिनल ऑफेंस नहीं माना जाता जब तक कि उसमें इंटेंशन इंक्लूड ना हो क्राइम को कमिट करने
Yes, now your audio is coming. Okay. Am I audible to everyone now?
Yes, ma'am.
Okay, thank you. So let's get back. I'm so sorry the call got disconnected. So I'll just share this screen again. So we were talking about what are the essential conditions. We mentioned that the Latin maxim that works out here is actus non facit trium nisi mensit tria, right? The two components are actus reus and mens rea. Actus reus becomes your physical element, right? The action that you are doing, that is wrong. And mental element is the thought that you want to do something wrong and you still go ahead and you commit the wrong, right? So your mental element is your blameworthy mind. Before we move ahead, let me ask you a quick question. I'll give you 3 situations and you have to tell me that out of these 3 situations, which of the situations is actually a wrong situations? In the sense that in which situation would you say that the guilt that has been ascertained or a person has been held guilty is actually a wrong situation? So please hear the 3 situations very carefully and the correct answers you can post in the chat box. So let's say situation number 1, I give you a situation wherein let's say A is taking a gun and he takes an aim at B, right? He triggers he pulls the trigger and B gets hit. He's taken to the hospital, but before he could reach the hospital, he dies. In this situation, A is charged with murder, right? So the question is it correct to charge him with murder? Let's come to the second situation. Let's say A is a Hindu. I'm sure you've read family law, and because you've read criminal law, I'm assuming that you understand this. A is a Hindu. He's already married to, let's say, B. Now, he enters into a marriage with C. And then because of his marriage with C, he is charged with bigamy. Okay. So this is the second situation, wherein A, being a Hindu, he's getting married. He's already married to B, and now he's getting married to C. This marriage is done. He's charged with bigamy. Let's talk about a third situation. Let's say somebody makes a poisonous halwa. Let's again talk about A. He has made a poisonous halwa and he wants to give it to B to kill him. So he says that, okay, B, will you have the poisonous halwa? But before B could actually take a spoon and take a bite of it, a lizard falls into that plate. And B says, I'm not going to eat this halwa. So he leaves it. He sees the scene and then he feels very guilty that I wanted to kill him. So A confesses to B that, I wanted to kill you, so I made this poisonous halwa for you. And B says that you will be charged with murder. Now, in these 3 situations, where in first situation, A has shot B and he dies while he's being taken to the hospital, where he's charged for murder. Second situation, wherein A is charged with bigamy because he's committed a second marriage. And the third situation, wherein because he has made a poisonous halwa, and even though he could not take it, he is charged with murder. Now tell me, in which of these 3 situations saying that A is guilty is wrong? Which is that situation wherein you cannot say that B is guilty?
See,
Okay, anyone else? You can put your answers in the chat box. I'm going to give you a minute to think about it. Think about it. One person says that C, situation 3 is the only one where the charge of murder is wrong. How about the situation 1 and 2? Are the charges correct? Think about it. You have to tell me which situation is wrong, that this situation should not be, this is charge to be placed.
Ma'am, could you please repeat the situation?
Okay, so the second situation, that A is a Hindu, he married to B. Okay, he then goes into a second marriage with C. So he is charged with bigamy. I hope you all understand bigamy. Bigamy is having more than one wife, right? And for Hindus, it's not allowed. So he is charged with bigamy. Situation 1 was wherein A pulled the trigger and Shot B got hit, and while being taken to the hospital, he passed away. So A is charged for murder in that case also. So you have to tell me in which case have they charged A incorrectly. Okay.
Ma'am, according
Yes, you can unmute yourself and please go ahead and say, or you can just post it in the chat box. That's easier.
according to the situation, so in second situation, he is liable for the bigamy. Or in third situation, he is not liable for murder because he can commit the attempt to murder, but he is not liable for murder.
Sakshi, how about you put this in the chat box so that everyone else can also read what you are saying? Because there's a kind of disturbance in the voice, that's what I'm saying. How about the others? Anyone else who has an answer to this question? No one else? All right. So let's understand these three situations. In the first situation, when we have talked about actus reus, what makes an action an actus reus? Actus reus is not an action. Actus reus is an action that is prohibited by law. So not all actions are actus reus, you have to understand, right? Any action that is prohibited by law, criminal law, becomes an actus reus for a crime. So in the first situation, the action causing, actually taking the gun, pulling the trigger and shooting someone is what is actus reus. So the first situation tells you that actus reus includes conduct, right? But it is not always the conduct only that will constitute the actus reus. You see that in the second situation. Why I say is because you see in the second situation, what is the action? The action is getting married. Is getting married prohibited by law? No. What makes that action an actus reus is the circumstances surrounding that particular action. And what are the circumstances? First, that he is a Hindu, and second, that he is already married, right? So it is not the action of getting married. It is the action in the circumstances which make an action a actus reus. So actus reus will not just include conduct, it might also include the circumstances. It will be the circumstances that make an action an actus reus. Right? So because in this case, we say it's not the conduct, but the circumstances in which the conduct has happened, that is making the action actus reus. Let's talk about the third situation. In the third situation, what was the intended result? That B should die. Did B die? No. Which is why when you do not have the consequence, when you don't have the consequence that you intend to have, the action remains action only. It doesn't become an actus reus, right? So here, when you talk about conduct, that I prepared a poisonous halwa and I threw it away, does it become a crime? No, it doesn't. Only when I get to the intended consequence, that I give it to someone and that person eats it and dies, only then will it become murder, right? So here you have to understand that actus reus doesn't always mean only a conduct. It can be conduct. It can be the circumstances in which the conduct has happened, which will convert the action into actus reus. And third is the consequences. We'll read these three in detail also now. Let's talk about the third. Just a second. Sorry. Let's talk about conduct per se. Is the slide visible to everyone completely? Just give me a yes or no if the slide is completely visible.
Yes, ma'am, it's visible.
Yes, ma'am.
Thank you. Okay. Let's talk about conduct. Now, for a conduct to become an actus reus, the law, criminal law says that has to be two essential components. First, It has to be an action. Now, action doesn't mean you doing something. It could also mean that you are not doing something. Basically, meaning it could be an action. It could be an omission also. Okay? So earlier, when we had IPC, there was section 32, which said that, an active state can be an act or omission. Now we have section 3, clause 4 in the BNS, which talks about this. Right? So it could be your action. It could be your omission, which ultimately becomes an active state. What is very important when it comes to omission is that you will only be held liable for not doing something when you had a duty to do that. For example, a doctor who's conducting a surgery has the duty to complete it properly, has the duty to ensure that he doesn't leave his medical instruments inside the body. So he has a duty to act. When he doesn't do that, that becomes an omission, right? Otherwise, a doctor who is, let's say, in other hospital, will he be liable for somebody who's dying in another hospital? No, because that doesn't amount to omission. He did not have a duty to act. So only when you have a duty to act and you don't do it, doesn't omission become an actus reus, right? Now, your action, the actus reus of your crime could be a combination of both the action as well as omission, right? That is given under section 36 of IPC, and under the BNS that has been given under section 3, clause 7. Now, I just want to give you a minute to think of an example that you can give me wherein an actus reus could be made up of an act and omission both. Take a minute to think. Reply to me in the chat box with the situation. Or if you have the answer, you can raise your hand and I can allow you to speak and you can share it with the class. Take a minute to think. I am talking about a situation, an actus reus, which is the result of both an action as well as an omission. Think about it. For those who still have a doubt in understanding my question, I'm saying I need you to give me a situation in which the actus reus is made up of an act as well as omission. That there is something that the person had to do, he didn't do, and also he did something that is wrong. Anyone? You can raise your hand and answer. I told you, you'll have to participate a lot in this session. So this is the participation that I'm expecting from you. Anyone you can message in the chat box, or you can raise your hand and I'll give you a chance to answer. Or should I randomly call somebody and ask them?
Ma'am, may I?
Sure, please go ahead. I
Ma'am,
cannot
for
read your name
example,
because your name says just iPhone. So can you introduce
ma'am,
yourself, please?
ma'am, I am Aditya Garg from CPJ.
Okay. Hi, Aditya. Please tell
Thank.
us.
So, ma'am, basically there is a hypothetical situation which says that it is the duty of a swimming instructor or a lifesaver to save someone from drowning. But if he failed to do so, if he failed to fulfill his obligation or his duty while performing such task, therefore he will be held liable for such act or omission.
No, my question is, you are correct to the extent of omission. That he had a duty to act, he didn't do it, which is why this person, let's say, he drowns. But you have to say that you have to combine it with an action also. So the actus reus, that's the tricky part here. This actus reus, the examples that you're giving in this actus reus, you don't have to just say that there was omission. You also have to include an action that led to the crime.
So,
If
ma'am,
you can,
basically,
yes.
I have to involve this one in act as well.
Yes, you
Like,
have to include a guilty act also, not just a guilty omission.
okay, thank you for correcting me, ma'am.
Think about it. Think about it. Maybe you can only come up with the correct answer. Anyone else? Please.
Ma'am, may I please try?
Yes, Vanshika, please go ahead.
Ma'am, like in tort, we have read that negligence is there on doctor's part. So let's suppose a situation where the doctor was doing surgery and while performing the surgery, mistakenly he put the scissors inside the stomach while performing any sort of a surgery, as a result of which there was the death of the patient. So here it was his act not to do such type of negligence, and due to the omission of that wrongful act, he can be considered guilty, as a result of which his medical practicing certificate could be taken and further he could be punished.
Very good. So Vanshika and Sujata, I think, were thinking completely on similar lines because she's given also the same example. So good, Vanshika and Sujata, good Aditya. I'm sure that situation can be changed a little, wherein the swimming instructor, uh, he has a duty to ensure that people do not really falter while swimming. They have all the proper equipments, but instead of ensuring that proper equipment is there, the swimming instructor also switches off the lights while he sees that the person is drowning. So here there's an omission also on his part as well as act. So I guess Aditya, you have also understood how we can combine action and omission both. So very good. I'm glad to see that you guys are participating and you guys are involved in the discussion. Very good. So this becomes a part of actus reus rules that, if there is a conduct, it need not only be an action, it can be an action as well as omission. The second important aspect of actus reus is that action that you're doing has to be done willingly or voluntarily. Now, when we had the IPC, we had section 39, which talked about the concept of voluntarily. Basically, it talks about anything that you do on your own will. You have control over your actions and you take a conscious decision that I want to do this. So this has to be the actus reus, that when you're doing it, you do it willingly, not because somebody is forcing you to do. Right? So if somebody is pointing a gun at your head and saying, shoot someone else. So even though you are doing an actus reus, your action is the one that is causing the death of someone else. It is your action. You're pulling the trigger of a gun and shooting someone. But you will still not be held guilty because you are not doing it willingly. You're doing it because somebody has put a gun on your head. So the voluntary part is very, very important, right? And somebody might confuse that. Is it the same as mens rea? No. This factor will vitiate mens rea, right? I am under duress. You've read contracts, I'm sure. I'm under duress. I'm under coercion. That I'm picking my gun. I know that when I pick my gun and I pull the trigger, I will shoot someone and then he'll die. I have the mens rea, but my actus reus is not done willingly, which is why even though there is a mens rea, the action will not be called a actus reus. I hope there's no confusion between willingly doing an action and mens rea, right? So this is what constitutes your actus reus. The conduct that you are doing, that conduct has to be done willingly. It could be an action, it could be an omission. Now, let's talk about those circumstances wherein conduct need not be a guilty conduct, but it is the circumstances which make the conduct guilty. Now, when we talk about, is the entire slide visible to you people?
Yes, ma'am.
There's no obstruction, right? Okay, great. When we talk about circumstances, I just gave you an example of a bigamy. There can be a lot of other examples. For example, it is an offense to receive stolen property, right? But the mere fact that I'm taking somebody's property is not, that conduct is not wrong. What makes it wrong is the circumstances. What circumstance? That it was stolen from someone else, right? A lot of people exchange things from each other. What makes that interaction a crime is that it was already stolen. That is the circumstance in which this transaction that is happening becomes an actus reus. Now, like it says, the external factors in which the conduct or the results of the conduct occur, that are the circumstances which ultimately make a conduct an actus reus. And sometimes it's not, like I said, sometimes it's not the act, but the circumstances around the act that make it an actus reus. Let's talk about consequences. Now, when you look at the offenses under IPC, you'll realize that a lot of offenses say that merely committing an action, like initially, I think I'm so sorry, I forgot the name of the person who answered. Somebody said that what are the essentials of crime was that actus reus, mens rea, and injury. And this is what we're going to talk about here, that there are crimes. There are crimes in IPC and now BNS which say that you need not have an injury. Irrespective of whether there is an injury or not, if you are doing that action, that itself amounts to a crime. For example, as simple as that, we've talked about inchoate crimes or base attempt. That even the very fact that you are attempting something, that itself makes it a crime, right? You have crime of attempt. But some cases, harm is very essential because that determines, like somebody just mentioned that, ma'am, it will not be culpable, it will not be murder, it will be culpable homicide amounting to murder. The fact is, it will not still be culpable homicide amounting to murder because it would have been culpable. I mean, I don't want to go into that discussion of why at the last of the class, so you can probably mail me to discuss this more. For culpable homicide amounting to murder or not amounting to murder or murder, for all these three offenses, the most essential factor is the injury of death. Unless there is a death, you will not apply these sections, right? So there are certain sections wherein unless and until there is not an injury, you do not call it a crime. So for example, simple hurt versus grievous hurt. How do you determine which is which? By looking at the injury that has been caused, right? So it is the consequence which is determining whether something is a crime or not, right? So when you talk about consequences, very importantly, you also have to look into one thing, that whether what I am doing and the consequence that is resulting from my action, are they really related? For example, if I switch off a fan here and in some other house, the fan falls on someone, or if I'm working on my fan and somebody else's fan falls, are they related to? So my conduct and consequence of somebody's fan falling are not related. So which is why it's very essential that you develop a causal connection between the conduct and the consequence before you say that it is an actus reus, right? Now, how do you see, how do you test whether this connection that is there between the conduct and the consequence, whether it's actually close, because it has to be proximate. It cannot be a remote connection. When I say it cannot be a remote connection, it simply means that as a person doing the conduct, I should be able to reasonably foresee. I'm sure you're reading that in torts law. You've read that in torts law. You've read that in criminal law also. That there has to be a reasonable foreseeability. I should be able to see in the future that if I'm doing this action, probably this can occur, right? But how do you determine? How do you determine what is the causal factor here? How do you establish that causal factor? There are certain tests for that. The first test is the but-for test. I'm sure you've read this when you're reading criminal law. Let's just think that this is kind of a revision, and wherever BNS has brought in some change, we'll look into it, right? So, but let's just brush up our concepts. And if there is anyone who has a doubt in whatever we are discussing, if you think this has not been discussed or I'm saying something that's not what you've discussed, you can put it in the chat box and we can stop and we can look into that. So when we talk about the but-for test, now what is the but-for test? It is as simple as something that this consequence would not have occurred but for my conduct. So had I not done this conduct, this consequence would not have occurred. Simple. Had I not plucked an apple out of a tree, it would have not been detached from the tree. Right? Had I not thrown a stone on somebody's head, the injury would not have occurred. Had I not taken a gun and shot someone, that person would not have died. So that person has died because of my conduct. That becomes a test, the but-for test, that you look into whether the consequence would have prevailed, whether or not I would have committed the action. So if I have committed the action and it is because of my action only that the consequence is arising, that means it is but for my conduct, the consequence is not happening. So that becomes your but-for test. The second test is the test of causa causans. Let's understand what it says. It says that the act must be the causa causis, that is the immediate and not remote or accidental cause of the effect, right? That if I had an argument with someone, somebody was like, okay, I'm very angry with you, I don't want to talk to you. That person leaves the room because he had an argument with me. And when he leaves the room to go to his house, during the travel, he meets with an accident and dies. So somebody says that, you are guilty of murder because had it not been for your argument, he would not have met with an accident. Are they two related? No. The reason why that person got killed was because of the accident. That had nothing to do with my having chit chat with that person or having an argument, right? So everything that happens, it's a chain of events, right? But to link the consequence to a crime, that has to be the immediate cause, not the cause. So it's A leads to B leads to C leads to D, and D ultimately leads to the injury. So your action has to be the D part of it, not the A, B, and C. It has to be the immediate cause. Okay. Then comes the third factor, supervening factors. I take a gun, I shoot somebody, right? I pull the trigger, the bullet fires. This person is standing between there. Now there is someone else who enters the scene and the bullet hits him. He is a person of supervening, an intervening factor, right? So does that affect the fact that I will be held guilty, right? Or let's say, I'm sure you must have heard about accidental firings, right? That I take a gun and I'm shooting, let's say, I'm in a shooting club when I'm taking aim at one of the balloons, let's say, that's hanging, right? You all see these in fairs and melas that you have the balloons and you shoot. Now, let's say I'm taking a gun and I'm trying to shoot at the balloon. And then while I was taking an aim, somebody hit my elbow from the behind. My aim, it gets distracted and the bullet hits somebody else and injures him. Now, this person, I wasn't really doing a crime. I was just trying to hit a balloon. But this person came and made me commit an act, which became a crime because that person is injured. Will I be held guilty? That is what you have to look into. That when someone else comes into the picture between the offender and the victim, how does that affect the liability? Is it affecting the liability or not affecting the liability? Now, there could be a lot of factors, a lot of supervening instances, supervening factors that can come into place. But before we move on to that, any person who has any doubt till here, you can please raise your hands and ask me. Otherwise, we'll move ahead. Is there anyone who has a doubt? You can put it in the chat box. Or you can just unmute yourself and please ask. Anyone who has any doubt? Yes, Sujata, please. Sujata, please unmute yourself.
मैं एक
Yes,
सिचुएशन बताती हूँ
sure.
मैं एक सिचुएशन बताती हूँ आप उसमें मुझे बस आंसर कीजिएगा कि उसमें लायबिलिटी थी या नहीं थी सो सिचुएशन वाज दैट कि फॉर एग्जांपल कोई क्या हुआ कि ड्यूरिंग लेबर पेन उसकी डेथ हो गई और उसके घर वालों ने चिल्लाना स्टार्ट करा कि बिकॉज ऑफ दैट गायनेकोलॉजिस्ट उस बच्ची की और उसकी मदर की दोनों की डेथ हो गई है तो इस सिचुएशन में इन सब चीजों से उनकी चिल्लम चिल्ली से जो गायनेकोलॉजिस्ट होती है वो सुसाइड कमिट कर लेती है अब इस सिचुएशन में क्या वो अबेटमेंट कहलाएंगे या वो लायबल होंगे या नहीं होंगे क्योंकि उसने सुसाइड कमिट कर ली जस्ट बिकॉज उन्होंने इतना ज्यादा एलिगेशंस वगैरह लगाए उस गायनेकोलॉजिस्ट पर उसको मेंटल ट्रॉमा हुआ जिसके कारण उसने सुसाइड अटेम्प्ट कर दिया
Okay. Before I answer Sujata, is there anyone else who wants to take the chance to answer it? Anyone? Anyone who wants to take a chance to answer this? You could be right and you could be wrong. It's completely fine. We're just discussing. Sakshi, yes, please. Please, go ahead.
मैम अकॉर्डिंग टू आईसीसी हमने चीज करी थी कि अटेम्प्ट टू सुसाइड नहीं बोल सकते कि अगर हम किसी वर्किंग एरिया में या किसी भी फिजिकल रिलेशनशिप में किसी को भी किसी तरीके से जैसे कि एग्जाम्पल था, इसका एग्जाम्पल था कि एक वर्किंग मैन था जो वर्क करता था, उसको उसके काम से निकाल दिया गया था और इस एक्शन में सुसाइड कर लिया था और बोला था कि अटेम्प्ट टू सुसाइड माना जाएगा, बट ये अटेम्प्ट टू सुसाइड कंडक्ट नहीं किया गया था क्योंकि हम किसी को दबाव देना, जैसे कि जैसे एग्जाम्पल सुजाता ने बताया गाइनोलॉजिस्ट वाला, हम गाइनोलॉजिस्ट को अटेम्प्ट टू सुसाइड नहीं बोल सकते, जैसे हम उसको उस चीज के लिए नहीं बोल रहे कि तू सुसाइड कंडक्ट कर या अपने आप को हार्म कर, हम अपना इफेक्ट बता रहे हैं कि हमारे साथ ये हुआ, इसलिए हम उसको अटेम्प्ट टू सुसाइड कंडक्ट नहीं कर रहे।
Okay, anybody who, very good, Sakshi. Anybody who wants to contradict what Sakshi has said, or anybody has any other reasoning? साक्षी नहीं, सुजाता का ये कहना है कि एक गायनेकोलॉजिस्ट है जिससे जब वो डिलीवरी करा रही थी तो वो मदर और बच्चे को नहीं बचा पाई, एंड जो फैमिली वाले हैं वो बहुत ज्यादा हल्ला मचाने लगते हैं, उसे बहुत ज्यादा अक्यूज करते हैं, कहते हैं आपकी गलती से हुआ सब कुछ, उस स्ट्रेस में आके वो सुसाइड कर लेती है। यहाँ फैमिली को अबेटमेंट के लिए हम गिल्टी मान रहे हैं, अबेटमेंट ऑफ सुसाइड के लिए, कि आपकी वजह से उसने सुसाइड किया। तो सुजाता का क्वेश्चन ये है कि क्या ये माना जाएगा। साक्षी का पॉइंट ये है कि हम इसे नहीं मानेंगे क्योंकि हम ये नहीं देखते कि हम प्रेशर्स नहीं देखते हैं कि क्यों किसी साक्षी, आई होप आई एम गेटिंग योर पॉइंट राइट, दैट when we are looking at it, we don't look at the pressure that a person is subjected to, right? Is that what you were trying to say?
Yes, ma'am.
Okay. Yes. Anyone else who wants to contradict?
Ma'am, in this case, ma'am, the gynecologist was the authority, responsible authority, and ma'am, the person who have accused the gynecologist is not liable because, ma'am, uh, uh, he was just making sure that she.
Nitin, आपकी आवाज actually I can't hear you clearly. Can you repeat what you've said? Nitin, I cannot hear you at all. If there's anyone else who was able to hear Nitin, can they repeat what he said? Am I audible?
Yes, ma'am.
Okay. Shailesh, can you please repeat what Nitin said?
Ma'am, I was not able to understand him.
Okay. Nitin, can you please repeat yourself? Nitin, can you please unmute yourself and repeat what you just said?
I think there's a network problem with Nitin, I guess.
And anyone who could hear what he was saying, I could just understand halfway that he was saying they will not be held guilty, but why I did not understand. Anybody who was able to understand and can put up his point? Okay. Okay.
Ma'am,
Yes.
Ma'am, I was saying that, ma'am, in this case, ma'am, the gynecologist was the responsible authority in this action, and ma'am, the person who were accusing the gynecologist for the act done by her, ma'am, they don't know about the consequence that the gynecologist will attempt a suicide, and they were just trying to answer the questions, that arguments that they were having in their mind, and they were not knowing the future consequences. So that's why, ma'am, in this case, ma'am, the person who were argumenting upon or accusing her will not be liable for any.
Okay. Anybody else who has a different view? Because I think Sakshi, I guess I'm so sorry if I'm naming her wrong. Sakshi and Nitin had the same point of view. Anyone else who has a different point of view here?
Ma'am, may I?
Sure, please. Aditya,
Ma'am,
right?
yes, ma'am. Ma'am,
Yes,
my
Aditya.
point may be different from others, like
Okay.
totally different. So, ma'am,
I
basically,
would just request everyone who's answering that I have given you 3 tests, right? Apply these 3 tests, and then with the application of 3 tests, give me your answer. That because of this test, this is the answer. That would be much better because we've been discussing this, right? So might as well use the knowledge that we have just gained. Anybody who could, or Aditya, because you're speaking, let's go ahead with you only. Apply this test and tell me how by application of this test do you arrive at your answer.
might be the third factor will be applicable to this case, and eventually it is a murder. I think so. It is a suicide. Sorry.
Okay.
As due to
Anyone else?
supervening factors.
It is
Any
a
injury
suicide. That
caused
is
to a
not.
person.
I don't think that there's any confusion because that woman is no more. So in the example, I'm sorry, but that woman is no more, unfortunately. So it is a suicide. The question is, will the people, will the family members be charged for abetment of suicide or not? Anyone? Aditya, do you want to answer this?
Ma'am, might be second because there is a kind of anger or frustration or putting off the coercion or putting some um, deep scars on someone's mind, like disturbing their mental health by causing such kind of chaos and might be leading to the suicide.
Okay. Chalo. Now let's not jump to the answer. Let's solve the question. Okay. हमारे यहाँ conduct इस पूरी situation में what is the conduct? The family members of the deceased lady and the unborn child shouting on the gynecologist and abusing her. Okay. Am I right? Sorry. Am I right? The person who has asked the question.
Yes, ma'am, you are right.
Yes, Sujata. Yes, of course. Thank you. So
Sujata.
that is the conduct that family members are have abused and accused this gynecologist. Right? The consequence here is the suicide of the doctor. First test, the but-for test. The question is, had the simple answer, the simple question that you have to ask, would the woman have committed suicide had it not been for the yelling and the abuse of the relatives? This answer is not very simple because there could be a lot of other factors that may have also contributed to the lady doctor, the gynecologist committing suicide. So the but-for test, you cannot, unless, let's say, that woman, I'm giving you a circumstance, unless that woman specifically writes that I am committing suicide because of what they have done to me, only then your but-for test will be cleared. Because then it very clearly explains that it is only because of this action that the consequences occur. But does not mean that every teacher who yells at a child and the child commits suicide, so you say, yes, the but-for test is applied, so the conduct becomes satisfied. No. The second test becomes equally important, and that is the causa causans. That when that person is yelling, when the teacher is yelling or the relatives are yelling, could they have reasonably foreseen that this would be the consequence? If the teacher is yelling at a student, can she or he reasonably foresee that a person will commit suicide? No. Right? Similarly, in this case also, unless and until the facts can prove that the relatives were yelling at her that you should commit suicide, you don't deserve to live, it is you who should go ahead and kill yourself. Unless it is specifically proved, unless it's done that, otherwise you cannot say that this was the immediate cause, right? It will be a remote cause, something. Why we call it remote? Because the person committing the conduct could not have reasonably foreseen that this could be the consequence. We all yell at each other. Just imagine a person is shouting at each other, putting out an anger, and the person commits suicide. Can you say that this is what you could have foreseen? No, unless you are poking him. And what I'm trying to say is go and commit suicide. This is what I'm basically trying to tell you. This is what you should do. So then it becomes abetment of suicide because you're instigating that person. Otherwise, no, that will not be a case of abetment of suicide. Sujata, am I clear? Was I able to answer your question?
Yes, ma'am.
Yes. Anyone else who has any doubt, or otherwise we'll move ahead? We'll move forward then. Otherwise, if there's no other person who has a question, and if you have, you can just raise your hand and ask the question. There's no one? Should we move ahead then? Should we go ahead with this next slide?
Yes, ma'am.
Okay, great. Now, let me give you 3 situations. I'm talking about the interventions that can come. I'm going to give you situations wherein some kind of intervention happens, and you have to tell me in which of these cases can you hold the person who is actually committing the act as guilty. Okay. Let's talk about a first situation. Let's say there is a bus driver who's driving a bus from Delhi to Shimla. Now, somewhere in the middle, the bus stops and the driver, he takes out the key, keeps it in his pocket and goes to have tea. Now, the passengers are sitting in the bus. Majority of them are sitting there. Very few have stepped out. Now, there is a thief who comes. He snatches the chain very quietly. The bus driver doesn't even realize that the key has been taken out from his pocket. And he takes out his wallet also, right? He goes to the bus, starts the bus, and he's confident he can just take the bus and steal the bus only and he'll manage. But unfortunately, what happens is that the bus gets out of control and hits, let's say, a tree. And a lot of people are injured. Some people die also. In this case, the bus driver is held guilty, right? Saying that because it was you are the driver of the bus, you are the one who's responsible. So you will be held guilty for murder and for causing grievous hurt to all of these passengers. This is situation 1. Anybody who has any doubt in situation 1 and wants me to repeat? Anyone? Please raise your hands if you want me to repeat the first situation. Otherwise, I'll go to the second one. No? Okay. Let's come to the second situation. I hope the first situation of the bus driver and somebody stealing his key and taking the bus and then making it meet with an accident is clear. Let's talk about the second situation. Let's say there is a person A. He wants to kill another person B. So he makes a poisonous drink and says and he calls B's servant. And let's say that B's servant is Z. So he calls Z and say that this drink is for your owner. So please go and give that drink to him. So Z takes the drink to B and B drinks it and B dies. Now Z is caught by the police and Z is charged with murder. Right? So the question is Z charged correctly? Now, again, let's come to the third situation, let's say. A is driving on a highway, okay? And he's driving at a highway speed and he can see that there is another person, let's say C, who's trying to cross the road. Now, because he's driving at a very high speed and he's not able to immediately see, he's listening to music and all. So he's not able to see C and he hits C and kills him, right? C is injured very badly and he dies. So he is killed. C is killed. Again, A is charged with murder. So this is the third situation. So now you have to tell me, write it in the chat box, that in which case do you think the person charged is not charged correctly? First situation wherein A, the bus driver, was held guilty for the Thieves Act. He is charged for murder and causing grievous hurt. Second, the servant is charged for causing murder to his owner by giving him a poisonous drink. And the third situation here, the person driving on the road is charged for murder of the person who was crossing road. Right? So you have to tell me in which of these situations the person is incorrectly charged. Please put your answers in the chat box. Is it situation 1, 2, or 3? Okay, situation 2 and 1, A and B. Okay. Anyone else? Which situations is it incorrectly charged? Okay. Okay. All are correctly charged. Okay. 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 Very good. I am very happy to see the participation that you guys are showing. Very good. Anyone else who wants to answer before I move on to the answers? Okay, very good. Very good. Okay, first one, first and second. Okay. Anyone else? Okay, let's come to the answers. And let's understand the okay, Harneet, you are saying 1, 2, and 3. What are they? All are correctly charged or all are incorrectly charged? Harneet, what is the answer? All 3 are correctly or incorrectly charged? Okay. By the time Harneet replies, let's understand the situation one by one. In the first situation, the question is, did the person who was driving the bus wanted to cause the injury of murder and grievous hurt? No. The next question is, this third person who came in the picture, did the bus driver put him in that place to execute the act? No. Which is why the bus driver will not be liable, right? Who will be liable? That person who has committed the accident. In the same situation, had it been the bus driver telling the conductor that, take the key and park the vehicle outside. Now, this place, it is the bus driver putting that conductor in that place. So the third person who's actually become a medium to commit the crime, he has been placed in that situation by the accused himself. So the accused will be liable, right? Otherwise, if the third person who is in the picture, right, if he has not been placed with the consent or at the behest of this person, because of whose actions the crime is committed, this person will not be liable, right? So if I choose someone to commit my crime, I will be liable, right? Because that person has been placed in that situation because of me. Otherwise, I'm not liable. Let's talk about the second situation, wherein the servant who's giving the poisonous drink, he's doing it on my instructions. He has no idea that the drink is poisonous, right? So this person is an innocent person. We call it intervention of an innocent person, right? That I wanted to kill B. And I was like, it's okay. I'm going to make, or let's say I made a drink and I kept it on the berth, that I'm going to kill B. And the servant comes and says that you have made it, no, I'll go and give it to my sahab. So he's an innocent person, he doesn't know, right? So if in your crime, an innocent person intervenes and the injury still resulted, because of that innocent person, you will not be held not guilty. You will still be guilty, right? So when an innocent person intervenes, there's no change in liability. The accused is still liable if he has caused the injury, right? Why we call it intervention is because this is not the act of the accused that is directly causing the injury. Somebody else has interrupted the chain of events. And it is this person's actions which have come between my actions and the injury. So we're trying to ascertain whether this person's action, the person who's intervened, whether his actions are the one that make me guilty or acquit me of guilt. So if it's a third person who has come in between and he has been placed by me to commit a crime, then I'm guilty. But if he has come in between without my knowledge and then he's doing something that leads to a crime, I will not be guilty. Again, if this is an innocent person who comes in between my actions and ultimately leads to the injury, because he's innocent, I will still be held guilty. Let's come to the third situation wherein I'm driving on a highway and I can see that a person is crossing the road, right? But before we do that, just understand the concept. I'm sure in torts you've read the concept of contributory negligence. Can anyone quickly give me the concept? What is contributory negligence? Anyone who will explain to us what is contributory negligence?
Negligence on both the parts, that is carelessness from both the sides. An
And who are
example,
both the sides?
ma'am, the petitioner
Plaintiff
and
independent.
Basically, the person who's causing the injury and the victim, right? So when the victim is also in a way contributed to the circumstances that is resulting in injury to him, you call it contributory negligence. This is a concept of tort law, and contributory negligence has no place in criminal law, right? The general rule is that you do not have a concept of contributory negligence in criminal law. For example, in our situation, if you are driving on a road, law clearly says you have to be reasonable to expect that people will cross the road. So you have to control your speed. You have to ensure that your vehicle is running in a way or is traveling in a way that if there is a person there on the road, you can stop it. So when on a road, you have to expect it. And if you hit a person crossing the road, you cannot say that he was on the road. It is his contribution also. That is why he's hurt. No, right? So in the third situation, because I can see that the person is already crossing the road, you cannot say that the victim intervened. He came on the road. So intervention of victim does not absolve the accused from guilt. This is what we have discussed in this slide also. I request all of you to quickly go through this slide. When we're talking about unexpected interventions, I want to commit a crime, but suddenly a third person, something comes in between. So we have to see how does it affect the degree of my culpability. In the first situation, wherein, for example, we've talked about this thief who snatched the purse and key of the bus driver, we're talking about the third party. The servant who serves the drink and kills is the innocent person here. And the person on the road is the victim. Please read it and except the last part of exception of exhaustion of danger. I'll explain that. But otherwise, please read it. And if you have any doubt, please ask me. Please message in the chat box. Otherwise, we'll move to the last. I just want you to go through the slide once. Anyone, any doubt? Can we move to the exception? Okay. Now, criminal law says that, victims usually cannot be said that, you are the one who has contributed to negligence. But there is one exception that we create. That is exhaustion of danger, wherein you can see the danger right at the starting. You can see it right in front of you, and you still go ahead and face it. For example, in the third situation, that's a very simple example. I can see that there is a car coming at high speed. And you must have heard of these incidents that, this is how some people make money. That when they see a vehicle approaching, they jump in front of it. So that the other person who's driving will get scared and say like, oh, and then they'll ask money from them. In such a situation, when you jump in front of a vehicle, you cannot say that this person is guilty. Then you are not a victim anymore, right? So what is the exception of exhaustion of danger? That when you see that the danger is right there in front of you and you still move ahead towards the danger, then you cannot say that the other person caused me an injury. Okay. That is all on mens rea. Okay. Or sorry, on actus reus. What did we discuss? Actus reus, it can be an act and omission and it has to be willed. It could be the conduct, it could be the consequences surrounding the conduct, or it could be the circumstances in which the action has been done. That will make it the actus reus. When you talk about the consequences, it's very important that you are able to link, you are able to establish a causal connection between the conduct and the consequence, and that causal connection has to be proximate. It cannot be remote. The person who is committing the conduct has to be able to reasonably foresee that this consequence could ensue. This causal connection is established by 3 tests: the but-for test, the causa causals, and by looking at the supervening factors. What could be the supervening factors? It could be an intervention of third party, when you'll only be liable if you were the one who placed that third party. And then the intervening factor could be an innocent person. Then you will still be liable because that person is innocent. And the intervening person could be a victim. Because there is no place of contributory negligence in criminal law, you will still be liable unless there is a situation of exhaustion of danger, wherein the victim has seen the danger and is yet moving towards it. That is what is all on actus reus. Let's quickly move to mens rea. What is mens rea? Mens rea is basically the mental element that we've already discussed. But mens rea is not always intention, right? Mens rea comes in varying degrees. And that degrees, I mean, is the thought that you have, whether you wanted to do it or did it just happen because, you were not very careful. So the degree of guilt varies depending on how much did you foresee that something can happen. We'll understand this by an example. Please listen very carefully. This is not going to be a question to you. I'm just going to explain 4 situations to you. Let's say you are sitting in a class and your mother gave you a banana to eat. You ate it, but the peel is with you. Now you're like, I have to go and throw it. But you suddenly realize that the teacher is in the class. Now you're like, okay, once the class is over, then I'll throw the peel outside. So what you do is you keep it on you keep it somewhere near your desk or something, right? Let's say situation number 1. What happens is there is a person who's coming from behind you, right? You don't know that the person is coming behind. You are working and suddenly because you're doing something on the desk, the peel falls off, right? And this person is walking, he also was not expecting. He steps on the peel, slides and falls on his back, breaks his back, and it's hurt very bad. Situation number 1. What had happened? What did you do? What did you do? You had placed a peel, and while working, you didn't see it fell off. You didn't throw it, it fell off. You had kept it there so that you can throw it after the class is over. This is situation 1. Let's say in the second situation, let's twist the first situation only a little bit. Let's say the class has started. There is someone who is coming outside, who's coming behind you. But before that, let's change the middle part a little bit. Let's say you didn't keep the peel there, or let's say you had kept the peel and you saw that it had slided down. Okay. Your hand was there and then it went down and you can see that it's now lying on the passage. Okay. You're like, I'll pick it up. But your friend suddenly calls you. And instead of picking that up, you know it's in the passageway. Right? You know that it's in the passageway. You know that somebody could get hurt. But you're like, yeah, I'm picking it up. And the friend calls and you start speaking to the friend. Somebody comes from the back. Somebody comes from the back and slips on that banana peel and falls off. This is situation number 2. Let's say in the same situation, the banana peel that you have, you're saying that, I'll throw it and I'll there's a dustbin in the room. I can see it and I'll just, I'll take an aim and I'll throw it there. Right? You throw it, but it doesn't fall in the dustbin. It falls right somewhere in the middle passage. Somebody steps on it and falls, right? All you had to do was get up and go to the dustbin. Where you're like, okay, what I'll do is I'll throw it there and it will fall in the dustbin. There's no problem. It doesn't, right? It falls somewhere in the middle. Somebody steps on it, falls and hurts himself. The fourth situation. Let me quickly revise you the first 3 situations. First, the peel was there. It got displaced, fell down. You didn't see that. Somebody stepped on it. Second situation, it has fallen down and you can see that it has fallen down and you can see that somebody can step on it. But because some other person has called you, you start talking to that person. That peel is there, that the peel is there. It can actually, lead to somebody stepping on it and falling. The third situation is that you think I can throw it in the dustbin. You throw it, but it doesn't fall in the dustbin. It falls somewhere in the middle. Somebody steps on it and gets hurt. And the fourth situation, there is a friend that you really don't like. And I'll teach him a lesson. He's about to cross, you put the peel in his way, he steps on it and he falls. In all these 4 situations, there were the thought of causing harm to someone. Yes, the BNS covers the same provisions in IPC. If you read about the articles that are written on BNS, someplace you will find that they're written, it's basically the same as IPC. They've just clubbed the provisions, and that's kind of true. That you would see majorly, like what we were discussing here also, you would only see that the section numbers, especially not for everything. Like yesterday in your class, you must have heard that a lot of sections have been repealed, new sections have been added. So that is a change. But the concept that we are talking in this module, right? Because these are essentials of criminal law. This is what Indian criminal law is made up of. They have not been changed, right? So you only might see us, and again, the points that we're talking just now, these are principles. You will see them being implemented in various provisions, but as principles, they don't find place like per se that this is mens rea. You won't find them in the IPC also. These are concepts on which criminal law is built. Sujata, if the question is clear, can I move on?
Sure.
Thank you. Now, these are varying degrees of guilt. And how? Let's understand that. The first situation, wherein that person should ideally have gone and thrown it in the dustbin rather than keeping it, but never wanted to harm anyone. Didn't even think that it could, fall down and harm. That will be negligence. And that is the least guilty of stage of menstruation, right? Wherein just because a duty of care and precaution was not followed, somebody got hurt. That is called negligence. The stage wherein you thought that you will throw the peel in the dustbin, you knew there was a high probability. Any time you're trying to make a throw and you're trying to throw somebody in the dustbin from a distance, you know that there's a possibility, there's a huge possibility that might not land in the dustbin. Yet, seeing the risk, even though you don't want anyone to step on it and fall and hurt himself or herself, you still see the risk, right? You don't want that consequence, but yet you don't stop yourself. You still go ahead with that risk. You still go ahead with action. That's called recklessness. So after negligence, what is more guilty is recklessness. The third is wherein you saw that the peel has fallen. You could see that people are crossing, anybody can step on it. Here you have already realizing that yes, my actions can lead to a wrongful consequence, right? That is called knowledge. Even more guilty. And the final stage is when you're making a conscious decision to cause harm to someone, and that's called intention. So these are the varying degrees of mens rea. But again, because the next topic is determining culpability, what is culpable, what is not culpable, we have a few quick pointers to understand. The first is strict liability. As a general rule, we do not see strict liability under criminal law. Mens rea is an essential element, but there are certain welfare legislations as simple as that. I'm sure you've heard about the Bhopal gas tragedy, right? In the Bhopal gas tragedy, it did not matter whether the Union Carbide people wanted to cause the tragedy or not. So majorly in social welfare legislations that have been caused to ensure the benefit of people, if a person is conducting any risky activity and if it causes harm, we exclude the mens rea factor. We say it doesn't matter whether you wanted to do it or not, you will still be held guilty. That is only with the social welfare legislation. Otherwise, in criminal law, mens rea is an important element. So in that case, and if you have to decide whether mens rea is not, you have to look at the statute. Unless the statute very clearly says that mens rea is irrelevant, only then the element of mens rea can be excluded. Otherwise, as a general rule, mens rea, if you have to establish a crime, if you have to establish culpability, mens rea is required. The second rule for determining culpability is of vicarious liability. Similarly, like strict liability, criminal law does not have the concept of vicarious liability. So the top concepts that you see, that the master is held liable for the actions of the agent, or the licensee is held liable for the actions of the people that he's employing, that doesn't happen in criminal law unless the master or the licensee had himself told his servant or the employee to do that particular action. A very interesting concept of criminal law is transferred malice. For example, I think this is a landmark example that is given across law schools to explain transferred malice, is making a poisonous halwa for someone and somebody else accidentally coming in the picture and eating it and dying. For example, I make a poisonous halwa to give to Sujata, and Vanshika comes in and doesn't know that the halwa is poisonous, and she comes and eat it, and unfortunately, touch wood, just for the sake of example, she dies. So can I say that I never wanted to kill Vanshika? My intention was to kill Sujata? No, I cannot say that, right? Because here, Sujata died, or sorry, Vanshika died because of what I did, right? So here in this case, the action is there. The mens rea which was towards Sujata will now be shifted towards Vanshika, and I will be held liable. So my culpability will still remain. Just the malice, the mens rea will be transferred from the intended victim towards the actual victim, right? And the last factor that determines culpability is your motive. You cannot make someone culpable. You cannot decide that someone is culpable because he had a wrong motive to do something, right? As long as he didn't had an intention to commit a wrong, motive does not matter. And we read a very simple example in criminal law that if a person is committing theft because he wants to feed his poor children, though the motive is good, there is still an intention to commit a crime, that person will be held liable, right? But if a person, let's say, uh, is not causing you any harm, he's simply doing an action that is for his sake, but his motive is to cause you injury. But his actions don't constitute that. That will not be held to be a crime at all, right? So when we determine culpability, we look at the determining factors are strict liability. Only if the statutes say, will you exclude mens rea? Unless the master or the licensee has delegated the action, you cannot hold someone vicariously liable if the person has caused injury accidentally to someone else. Rather than causing it to the intended person, the malice is transferred and you are still held guilty. And as long as your intention is good, it doesn't matter. As long as you have the intention to conduct a crime, you still are held guilty, no matter what your motive is. Okay. That is all on mens rea. We'll move to the next topic, and mens rea and the culpability. If you have no doubt, we'll move to the next topic. Anyone else? Anyone who has a doubt, you can raise your hand or you can put a question in the chat box. Anyone who has a doubt, otherwise we'll move to the next topic. Anyone? Should we move to the next one? Next topic, people?
Yes, ma'am.
Okay. Now, we've talked about, what constitutes a crime, what are the factors that are important. The next thing is to understand that who are these people who can be tried by Indian criminal law, and that gets covered in the concept of jurisdiction. Now, when BNS came into picture, in the IPC, you had the entire 1 to 5 section talking about jurisdiction, and that talked about who can be tried under IPC. What BNS has done is it has clubbed all the 5 sections under section number 1. And then it has made sub-clauses, right? So when we talk about jurisdictions, basically the authority by which a court gets the jurisdiction, gets the authority to try and hear cases. When we look at the BNS or the IPC, it has 2 types of jurisdictions: intra-territorial and extraterritorial. Intra-territorial, as simple as that. If you are in India and you are committing a crime, you are liable to be tried under IPC, right? So when we talk about IPC, it was given under section 1 and 2, right? This intra-territorial jurisdiction. In the BNS, that has been covered under clause 1 and clause 3 of the BNS. And it simply says, as long as you are in India, doesn't matter whether you are a foreigner or you are an Indian. So if you're a foreigner and, if in India it is illegal to smoke weed, as a foreigner, if you're doing it, you will still be held guilty. You cannot say that back home in my country, it is not an offense. You cannot say that. If in India, it doesn't matter whether you are an Indian or a foreigner. If you are in India and an act is prohibited and it's called a crime, if you do it, you will be held liable. The tricky part here is the extraterritorial jurisdiction, right? So under IPC, you had it under 3 and 4 section. Now under BNS, you have it under clause 4 and clause 5. Now let's understand what it says. Clause 4 basically says that if you're doing any action, for which in India you are liable, right? If anything, any part of it, if you've done outside India also, even then you can be tried in India if it's an offense in India. I'll give you a very simple example. I'm hoping that you've heard about the concept of human trafficking. Have you heard about human trafficking?
Yes, ma'am.
Yes, ma'am.
So you buy people and you sell them somewhere. Let's talk about sexual trafficking, sex trafficking, wherein a person buys a girl from Nepal and brings her to India and tries to sell her in a brothel in Bombay. Now, selling a girl for prostitution is an offense in India, right? So a person is liable. Now, he will also be liable for the act of buying the girl for prostitution. He cannot say that, but I bought the girl in Nepal. He cannot say that, right? So that's what IPC says, that if you are liable in India for an action that you have done here, if you have done any action outside as part of this transaction, which is punishable in India also, then that you will be punished for that act also. So if you're selling here, which is an offense, you'll be charged here for selling. You will also be charged for buying a girl, even though you did it in Nepal. Okay. Let's talk about the next clause. That is clause 5. Now clause 5 is basically expanding the scope of the territory of India, because we say anything that you do in India, as long as you're doing it in India, that is punishable. Now, India does not just mean within India. India, as per clause 5, also means that in India means you are an Indian citizen. So if you are an Indian citizen, you are committing crime anywhere, you will be liable under IPC. So if there is an Indian terrorist who's committing a terrorist action outside, he'll be charged under IPC. He'll be liable under IPC. It also says that territory doesn't mean only the land. It also includes all the Indian aircrafts and all the Indian ships. So if you remember, there was this recent incident in, I think, one of the airlines of India, that one person had peed on other passenger. If you remember this incident, that person will be tried under Indian law, right? Because that Indian aircraft is also part of Indian territory. So if there's an Indian ship, Indian vessel in the sea, and you're committing a crime there, you will be tried under IPC or BNS also. Now there's no IPC, there's only BNS. You'll be tried under BNS also. The third says that as long as, it doesn't matter where you are, you could be anybody, you could be Indian, foreigner, you could be in any part of the world. But if you are doing a crime which is targeting a computer within India, then you can be tried under the BNS, right? So the computer source, as long as it's in India, you can be anywhere, you could be anywhere, or you can be an Indian foreigner. Your place or your citizenship doesn't matter. If you're targeting a computer resource in India, that means you're committing a crime against India, you'll be charged. This is what the concept of jurisdiction is under IPC, and that has been taken under BNS also, right? Now, we've talked about when can you charge someone, who can be the person who's charged, and what circumstances can you charge him. Let's move on to the last topic of our discussion, that once you've charged him, you've held him guilty, what do you do about it? You punish him, right? You punish him. But the question is, just saying that I'm going to punish that person, or that person should be punished, is that sufficient? Is that good enough to justify whatever you are giving as a punishment? No. So we have to look at, when you talk about punishment, what are the types of punishment that you give? What is the basis on which you decide that, okay, this is a good punishment, this is a bad punishment, this is a reasonable punishment? How do you reach to a conclusion that a punishment is justified? And why punishment in the first place? If a person has committed an act, why do you need to punish him, right? So let's start with the concept of what is punishment in the first place. Now, punishment, basically, when we talk about punishment, it is basically an undesirable or unpleasant outcome of a criminal, right? So anybody who's committing a crime, he never expects to be caught, right? And if he expects to be caught, he expects to be freed. He never expects that he will be behind bars. So when you're putting a person behind bars, whatever he has done, whatever he has stolen, he's not able to enjoy the proceeds of his theft. So this is an undesirable and unpleasant outcome, right? There are certain characteristics that should be there to ensure that something counts as a punishment. Firstly, when we say punishment is basically, it's a societal reaction to crime. And why we say societal reaction? Because any place a wrong occurs, the society, as individuals, we want the wrongdoer to be punished. So it's our reaction. We say that, if he has done something wrong, the wrong should come to him also. So it's a societal reaction. And for it to hurt the offender, there has to be an infliction on pain. That has to be a deliberate infliction on pain. He has to, it doesn't mean that, for example, a lot of our political leaders who are sent to prisons and they enjoy a very luxurious lifestyle. So there's no pain, right? So that doesn't amount to punishment. We don't call it a proper punishment because there's no pain. So that person has to be inflicted pain. He has to feel that pain. And that pain or suffering that we are imposing on that person has to come from an authorized institution. So I'm sure a lot of you must have heard about something called mob lynching or mob justice. Have you heard about this? Have you
Yes,
heard about
ma'am.
mob
A group of
justice?
people attacking an individual.
Exactly. When people decide that we are going to settle this cause here, we are not going to take him to court. That what they are doing is not punishment, because punishment has to come from an authority who has been given the power to punishment. So it has to be institutionalized, right? And why do we give punishment? Because that punishment will send a message to the society that if this person, after committing a crime, was punished, so any person who commits a crime will be treated in the same way. So that acts as a deterrence. It controls anybody who's thinking that, okay, I can also do a crime. I can also, similarly act, deviate. So that is a means to control that deviation. It's a means of deterrence, right? And like I said, that institution imposing the punishment, for punishment to be valid, it has to come from an authority. That person has to have the authority. So when you talk about, let's say, Kha panchayats, their punishment cannot be recognized under IPC or BNS or under law also, because they don't have the authority to impose that punishment, right? So we've talked about what is punishment and what are the essentials of punishment. Let's now talk about how do you justify, on what grounds do you say that punishment can be given. Now, before you read on to the slide, have you heard of the concept of welfare state? Anyone? I'm sure you've read about political science. Have you studied political science as part of your course?
Yes, ma'am.
Yeah. In that, did you study about the formation of society? How did society come into picture? Okay. For everyone who cannot recall, or if anyone who's not coming from a BLLB course, you could be BBLLB also. Let me give you a quick idea of how did these societies, how did these kingdoms come into picture? How did law come into the picture in the first place? What happened was that there were people, they were wandering like nomadics. There was no rule. People could do whatever they wanted. But then people decided that we need to have certain boundaries. I need to respect your boundaries. We need to respect my boundary, and we need to have protection. Nobody can come and kill us, right? It should not be the case. So what we'll do, we'll nominate a king, right? We'll nominate a king who will be our protector, and he will protect us. But for what he's doing for us, he's protecting us. What we'll do is we'll give away some rights to him. And that's how a state is formed. The state, I'm not talking about government. I'm not talking about BJP or Congress. I'm talking about the state. Let's say, for example, India, the Indian government. We have kept the government at the center. We are giving them power to rule over us, to give us security. And in return, they have taken away some of our rights, right? So when they say that we'll protect you, which is why I'm sure you must have heard that whenever a criminal case is filed, it's never between individuals. It's always between the state versus the offender. Why is it the state versus the offender? Because the state say, I have a duty to protect. I have a duty to protect all my citizens. But if a crime occurs, that means I could not fulfill that duty. I failed in my duty to protect you. That is why you were subjected to a crime. If I failed in my duty to protect, I will not now fail in a duty to ensure that you are served justice. How will I ensure that you get justice when something wrong has happened to you? I will fight the case for you. That's why the state represents the victim. So the state says, I'll fight the case for you. And the state also says that when I fight the case for you, I'll ensure that the offender is punished, right? So the justification, the first justification of punishment comes that the state has failed in its duty to protect, and which is why now is ensuring justice to you. And the state knows that if I have to ensure that there is no further cases wherein more people who I had to protect are made subject of crime, I will have to ensure as a necessity, I will have to ensure that the first offender is punished, so that sends a message to the entire society that don't commit a crime against someone else. Otherwise, you will be treated in the same way, which is why we say it's a practical necessity in which basically we are threatening the society. We are sending that message that take the punishment seriously, because if it can be served to one, it can be served to anybody who is committing a similar crime, right? So it's basically a threat of punishment, right? It's a threat to the society, a message of threat, which is a practical necessity. So now when people say that, okay, you have to punish someone, but why? It's a necessity, but why is it a necessity? There are two approaches that are taken by scholars. One is the retributive. Retribution. Anyone who can tell me the meaning of retribution? What is the meaning of the word retribution?
Giving the wrongdoer what he deserves.
Okay, I'm saying the exact meaning, the literal meaning of the word retribution. Anyone?
Maintaining giving a message in a society.
Okay, anyone else? Not there exactly. Anyone? Retribution, what does it mean?
Punishment for a crime.
No, retribution means revenge.
To deter
Simple.
someone.
Retribution means revenge. Simple. If somebody has stolen my purse, I'll feel so much anger. I'll be like, give me my purse back and I'll punish you. That's the simple, the most basic feeling that you get of revenge. If you've heard, if the ancient times when people would say a hand for a hand, an eye for an eye, that's simple. That's the most basic core form of revenge, right? But we've moved ahead from that. So we say, okay, if a person has been done wrong, the society feels bad. So the person who has committed a wrong, he should be punished because he deserves it. So revenge comes in this form, that because you did wrong, wrong should come to you. That's called retribution, retributive approach. The other approach says that, you should be punished because that's going to serve some purpose to the society, right? That is the utilitarian. I'm sure you've heard of the word utilitarianism. You've heard of Jeremy Bentham. Have you? Have you heard of utilitarianism? Have you heard of Bentham?
Yes, ma'am.
Yeah. So Bentham was talking about, the happiness of the maximum number of maximum people. So his simple concept was that we should do things that bring results. Anything that brings happiness to people should be done, right? Whatever brings maximum pleasure to people should be followed. We'll look at these two approaches in more detail now. Let's look at the first one. When we say, you should be punished because you deserve it. And as simple as that, that if you violated the rights of others, you should be punished because, it will restore the moral order of the society. People will be like, Chike, because he has been punished by law, we should not punish him. Mob justice, all of this will not come to picture. But there are two main problems. Firstly, when you say that, the moral order of the society will be restored, that's kind of too big an assumption, because firstly, there are two problems. Firstly, you don't know. Like, for example, let's take a most basic example of Nirbhaya rape case. Right? You punished those individuals. I'm not very sure. I'm hoping that some of you must have heard of the interviews that were taken of these offenders once they were inside prison. BBC conducted an interview, which was a very controversial interview. And one of the accused said that, what I did was not wrong. You're traveling in the bus in the late night and you're traveling with a boy. Whatever I did was not wrong. You deserved this. So, because now this is a man who has already been awarded death sentence. He's sitting on the death row and saying that that girl deserved whatever we did. We didn't do anything wrong. So, were you able to correct the moral order of the society? Were you able to correct the moral standards of that person? You could not, right? Does that mean that because you've given death penalty to that offender, does that mean that there's going to be no more rapes? No, that's not true. So saying that we are going to punish you because you did wrong, and when we punish you, we are going to set the moral standards of society in place, it's too far an assumption, too much of a positive attitude. That's not really happening. Also, you have to understand that if you're talking about the moral attitude of that person, let's say if there's a thief and you say, because I've punished him, now he'll become a good person. You never know. Maybe he has come from really poor family and he had to do it, not because he wanted. So there's nothing wrong with his morals, but there was a necessity. But you still have to punish him because he has committed a wrong. So you can't set the moral order in society, right? You can't set the moral order in society by punishing something, because it is not firstly the job, and it is impossible for a state to say that this is how I'm going to regulate the moral order. The second problem with this is when you say, if I punish someone, there'll be fairness in the society. How will the fairness come? Simple as that. when there is a rape occurring, what would fairness mean in literal terms? Fairness would mean that the person who has been victimized, he's given the position back. He's back to the original position. Can that happen in the instance of, let's say, death, rape? Maybe in theft, you can give the money back to that person, but he'll still have a sense of insecurity. So you can't bring fairness in the society by punishment. So this concept of retribution, that because you deserve it, you get it, and we'll restore moral order in society and fairness, that doesn't really sit well with a lot of scholars, which is why they had come out with a second approach that's called utilitarian. But okay, before we go to the utilitarian approach, any doubt in what we've discussed till now? Anyone? Let me quickly recap what we've done. We've talked about active spheres, we've talked about mens rea, we've talked about the degrees of mens rea, negligence, recklessness, knowledge, and intention. We've then talked about determining the culpability in terms of strict liability, vicarious liability, motive, and we've talked about transferred malice. Then we talked about jurisdiction. We came up to see what are the provisions, how do you talk about intra-territorial and extra-territorial jurisdiction. And then we finally came to punishment, wherein we understood what is punishment, what are the key components for anything to constitute a punishment, characteristics of punishment. And then we have started our discussion about how do you justify the punishment that you are giving, right? So in that, we're trying to understand the approaches that were taken. So initially, in the earlier days, there used to be a retributive approach. They'd say that, because you've done wrong, it should come back to you. And that will set the moral order of society. It came with two main criticisms: that firstly, you can't set the moral order in society by punishing someone. Secondly, you can't bring fairness. Somebody has been raped, you can't bring back whatever happened to them. Somebody has died, has been murdered, you can't bring that person. So a sense of fairness can actually never be established, which is why scholars came up with the next approach, the utilitarian justification. And this is what we've discussed till now. Anyone, any doubt till here? Anyone?
No, ma'am.
No? Can we go ahead? Anyone? Please take a minute more if you want to think about it. And then we can go ahead. We have time and we don't have much to discuss also from here. So if you don't worry about, I'll not run behind the schedule. So if you have it out, you can ask.
Ma'am, the purpose of law is, ma'am, not just to give a message in a society, but so also to make a fear of law amongst people, so that they could think of committing any crime.
Exactly. And that's what we're going to talk about in utilitarian, that it has to send a message also, right? It's not just about the individual, it's who has done the wrong, it's about the society, so that they also don't do any wrong in the future. Very, very good method. Anyone else? Anything to add? Any comment that you have to make? Anything that you think you want to point out? Are you able to understand whatever we have discussed till now?
Yes, ma'am.
Yes, ma'am.
Okay, good.
Yes,
All right, good. So let's talk about utilitarianism. You've read Bentham. Bentham talks about maximum pleasure of maximum number of people. Whatever gives happiness to people, we should go with it. And whatever brings pain to people, we should not do it. Right? The same justification they're trying to apply to punishment here, that you should punish someone because it will bring happiness to people. Right? It will bring happiness to the society. It will be what they morally desire. Right? Like when Nirbhaya was raped and when the entire thing happened, the society, as a society, we wanted, our moral standard said that the offender should be punished. So punishment should not be given to change his moral standards, right? But punishment should be given to satisfy our morals, the society's morals, that yes, if you feel that punishment should be given, yes, they will be punished. So we are trying to satisfy the people. We're trying to bring them a sense of happiness, a sense of peace, right? If somebody's property is stolen, if somebody's child is kidnapped, why are we punishing the offender? We are also returning them their kids back, their property back, but we're also punishing the offender, right? Not just fairness, but a sense of satisfaction, a sense of happiness, and a way of building trust in the government, in the state, that yes, they are going to protect me. And if they cannot protect me, they're going to ensure that the offender is punished. So Utilitarian says that you should have a punishment which serves purpose. And what are those purpose? Firstly, it should have a deterrent effect on that offender and on the society. So on the individual and in general also, what Nitin said, that it has to send a message to the society. There has to be a deterrence. People should stop themselves from committing crime. People should have a fear that if we commit crime, we will be punished. Then it serves the purpose of norm reinforcement. People know that, okay, this is the law. If I commit this, this is the punishment that is given. So if there's a gang rape, it may lead to death penalty also now, right? So this is norm reinforcement. People believe more in the law. Then something that we see now more happening with BNS, reformation, with community service, right? So you're trying to reform that person also. Punishment has to reform that individual also, right? Which is why we don't give death penalty as a rule. If we don't give death penalty as a rule, we give death penalty only in the rarest of rare cases. We try and see that if that person is reformed to the last extent, we try that. Only when we see that there's no chance of reformation do we give a death penalty. Then incapacitation. Incapacitation basically means that whoever is the offender, you make him unable to commit any crime. So when you put someone behind bars, he cannot come out and commit crime. Well, reality sometimes is very different, but usually the concept is that anybody who's behind bars cannot commit any more crime. So you have incapacitated him. You have made him unable to commit any crime, right? And the last purpose that should be served is vengeance or retribution, not in terms of revenge, but simply that I feel satisfied that if something bad has happened to me because of somebody, he's also suffering, right? So that I don't feel the need to take it out on him, right? So there should be no mob justice. The purpose is this. Let's next move to the next topic of what are the kinds of punishment. We have understood the theories, the logic behind punishment, why it's given. Now let's see what are the types that are given under our Indian criminal law. So under IPC, we had section 53. Now under BNS, they have all in fact from 53 to a lot of provisions, I think 75 of them, they've all been clubbed and we've been combined, I think from section 4 to 11 of the BNS. So there's a very small segment that now talks, a lot of provisions have been clubbed. Section 4 is the one under BNS which talks about what are the types of punishments that can be given. So when you look at punishments, we can categorize them usually into two. One that causes a kind of loss to your body, your bodily freedom, your bodily integrity, and one that causes you loss of your property. So the ones that cause loss of proprietary or your property is forfeiture of property and fine. The one that can cause injury or harm to your body or yourself, one, the most extreme form is death penalty. Then imprisonment, which comes in various terms. It could be simple, it could be rigorous. Something that's not given in section 4 but is discussed separately is solitary confinement. That's also a form of rigorous imprisonment. We'll discuss that in a little detail. And then something that's also been given under section 4 is imprisonment for life or life imprisonment. What has now been added under BNS, under the last clause in section 4 is community service. You've discussed this yesterday also with your mentor. We'll talk about that in detail. Let's go one by one. We'll start with the proprietary crimes. Forfeiture of property. What is basically anything, any property that you have accumulated incorrectly, we'll take it back from you. As simple as that. That if you have accrued any property out of a crime or by committing crime, we'll take that back from you. Now, initially when IPC was enacted, we had section 61 and 62, which used to specify forfeiture, it was allowed for a number of crimes. But in 1921, when the government realized that this has become a means for corruption, they abolished that section. But even now, under the IPC and now with BNS also, you can see the sections. There are very few sections, 3 sections namely, wherein you still have the provision for forfeiture of property. The government can still take your property. The first is section 154 of BNS that talks about when you're committing depredation. Depredation is basically attacking. So when you're committing an act, any kind of attack in a foreign country in which, let's say, India has an alliance with or we are in friendly relations with, if you're committing an attack there, then whatever property comes to you or whatever property you've used to commit that crime, under section 154 and 155, that property can be seized and forfeited by the government as part of your punishment. Then the next section is unlawful gains of public service. Any public servant who through his duty is committing any kind of corruption, is getting any unlawful gains, court will say, we punish you and all your property, apart from every other punishment that we are giving you, we will also forfeit any such unlawful gains that you have accrued. Right? Now, even though this was abolished, we had a very recent case in 2001 in which, the court said that considering the kind of money that public servants are making by their unlawful gains, I think it's time, we think that's time that the concept that was given under section 61 and 62 initially, that should be, reintroduced. It should not remain abolished anymore. And we should again have forfeiture of property as a proper punishment now. So for now, if you look at BNS, there are only 3 main sections under which you will find forfeiture of property as an offense. Okay. Let's move to the next one. The next punishment is fine. Basically imposing monetary compensation to you, that goes not to the victim, but to the state I'm talking about. You have a separate module in your course wherein you will talk about victim compensation when you're talking about BNSS. So I'm not touching that aspect here. I'm talking about the fine that is imposed and that goes to the state treasury, right? So under IPC, you had it under 53. Here in BNS, it's talked about in section 4 clause E. So 4 clause E specifies that one of the punishment can be fine, right? And 8 clause 1 says that fine should not be excessive. You can impose fine, but you should not be unnecessarily excessive in the amount that you are imposing, on the offender. Now, when we talk about fine as a punishment, there are various categories in terms of which the fine is imposed. So it could be the categories of offenses I'm talking about. So there could be offenses wherein they say that the only punishment that can be imposed is fine and the amount is unlimited. You can impose as whatever the judge thinks fit, they can impose as a fine. The second category is, they say, you must have read, when you're reading IPC, you must have read imprisonment or fine. So here fine is an alternative, but the amount is limited. Then there must be sections wherein you must have said that imprisonment and or fine. So this fine now becomes additional, and in additional, you would see there are certain sections wherein that they limit an amount of fine that, up to this much rupees. And some offenses where they say fine, you have to just impose fine. They don't place a limit. So that means the fine becomes unlimited, right? There's no limit imposed to how much fine you can give. So these are the 4 category of offenses wherein fine can be imposed. It could be just fine and the amount is unlimited. It could be imprisonment or fine, and they say that imprisonment or fine up to rupees this much, right? It could be imprisonment and fine up to this much rupees, or just imprisonment and fine. So and fine only basically means that the amount is unlimited. The next aspect when it comes to fine is that what happens, let's say an accused is given an imprisonment of, let's say, 2 months and a fine of 100 rupees, right? Or say the accused is given imprisonment of 1 year and fine of 200 rupees. But the accused is very poor and he cannot pay fine. In such cases wherein the accused cannot pay fine, the court says that, okay, you cannot pay fine, you will go an additional term of imprisonment against that fine. But how much will that term of imprisonment will be? That is not the sole discretion of the judge. There are rules set out for that also. The first rule, which like the law says that this imprisonment that you're imposing because the person could not pay fine will be in addition to what has already been given as a term of imprisonment. So if it's 1 year, and let's say if they are adding 30 days, so now the imprisonment is 1 year, 30 days. Okay. It will not just be 30 days, it will be 1 year, 30 days. And this 30 days, this calculation, I'm not saying it will be 30 days, I'm saying this calculation when they're doing it, the second rule says that you cannot give that term of imprisonment more than 1/4 of what the term is prescribed under this section. So let's say if there is, the section says it can be imprisonment and fine, the term of imprisonment that is given in the section, that default imprisonment, that cannot be more than 1/4, right? So if it's, let's say, 1 year here, your imprisonment that you're giving because he could not pay the fine, it cannot be more than 1/4. So 1/4 of 1 year is, let's say, 3 months. It cannot be more than 3 months, right? And then there is a scale given as to how much it can be. So if the amount, now you have to understand, when the IPC came, we're talking about 1860. People were not that rich. India was not doing financially that well. So the fine imposed was very less, right? But now times have changed, and thankfully the BNS, when it has come, it has changed the amounts also. So now, which is why initially the IPC used to say that if the fine is up to ₹50 and you cannot pay it, you will be given an imprisonment which will be less than 2 months. But now it is 5,000. So if your fine is up to amount of 5,000, you cannot pay it. What will be your term of imprisonment given? Anything less than 2 months, right? Then if the fine is 10,000, which was initially ₹100. So if it was anything till 10,000, if your fine is, and if you cannot pay it, you can be given an imprisonment, but that cannot exceed 4 months. And if your fine is more than 10,000, till 6 months you can be given. This is the scale that is given under BNS. And the minute you have paid the fine, the term of imprisonment comes to an end, right? Any doubt till here? Any doubt till here? Anyone?
No, ma'am.
We've talked about forfeiture of property and fine. Now, these are two punishments that cause property loss to the accused, to the offender. Now, let's talk about those offenses that cause bodily harm to the offender. The first and the most important is imprisonment, right? That imprisonment basically means putting someone behind bars, curtailing their liberty, right? Sorry. That is given under section 4 clause B and clause C of the BNS. Now, imprisonment can be of 3 types. Basically, 2 types only that is prescribed under law: simple and rigorous, right? When you talk about life imprisonment will always be rigorous. It will never be simple. Simple imprisonment is just when you keep someone in prison, you don't make them do any hard labor. They're just staying there, which is why it's also criticized a lot that if I have to just stay there, you must have heard about these jokes when somebody said that, if a person doesn't have really a shelter to stay at night, he'll go and slap a policeman so that he's made to stay behind in the police custody for a day. That way he'll get food also, and that way he'll get shelter also for one night. So that's a joke, but that's also the biggest criticism of simple imprisonment, that people will actually lose the fear of imprisonment. What are they doing? They're going, sitting there and happily coming back. There's no problem for them. It's actually an economic burden on the state that they have to bear the cost of one more person. So instead of giving simple imprisonment, why not give community service for such offenses, right? The other imprisonment that actually is a real imprisonment is the rigorous imprisonment, wherein a person is made to do hard labor, crushing stones, building rocks, a lot of hard work. And in this imprisonment, there have been landmark judgments. I'm sure when you are reading this in detail, today the time doesn't permit. If whenever you are reading this in detail, your instructor, your course coordinators can tell you that there are landmark judgments wherein the courts have said that if you're making a person undergo hard labor as part of rigorous imprisonment, you can't take that for free. You have to pay them something. You don't have to pay them as wages. When you talk about, you don't have to bring in labor law in between and give them wages, but you have to give them something. They're not bonded labor. They are prisoners. They're not bonded labor. So you can't ask them to work for free. You have to pay them something. And then comes life imprisonment. I was listening to the discussion yesterday. There is no really doubt anywhere within BNS also that simple life imprisonment basically means imprisonment for the remainder of your life. There used to be this confusion, right? That what does life imprisonment mean? Because there was a talk about where it means 20 years or 14 years, because there was a doubt because of the commutation of sentence provisions. But then when criminal law was amended in 2013 and 18, to ensure that the confusion goes away, when the legislature introduced provisions for which life imprisonment was given, they made it very clear that life imprisonment means imprisonment for the remainder of the person's natural life. Now, again, our legislature does things very interestingly. When they were doing this in 2018 and 13, when they were specifying that this is what life imprisonment means, when they were coming out with BNS, they could have just either mentioned it everywhere, or they could have just introduced a provision in the definition section that say life imprisonment means life imprisonment for the remainder of the entire life. They could have done this. Had they done this, the entire concept of is there a doubt, is there a problem with clarity, that could have all gone away. But law is very clear that if you're talking about life imprisonment, it means that the person imprisoned will be imprisoned for the remainder of his natural life, right? Coming to the next type of imprisonment, wherein a person is confined to a place, he's not given the opportunity to meet anyone, that's called solitary confinement. Right? That's given under section 11 of BNS. Initially under IPC, it was under section 73. You are completely segregated from the outside world and the fellow prisoners, and it is never the entire term. Now, again, solitary confinement can only be given when you are given rigorous imprisonment. These are never part of simple imprisonments. So when a person has been given rigorous imprisonment and he is a menace to the prison, or he needs to be treated more severely, then a part of his rigorous imprisonment he has to undergo as solitary confinement. But there are very strict rules as to how long can this be, how much can this be given. And it says very clearly that the entire duration for which a person is sent in that solitary confinement, it cannot be more than 3 months. And at a time, you cannot give it for more than 14 days at a time. So for more than 14 days, you cannot keep a person in solitary confinement at a stretch. He has to be taken out. If let's say 3 months also, 3 months you keep, bring him out of solitary confinement after 14 months, you make him stay outside, then you again send him back. But at a time, you can only send him for 14 days. Then there is a scale given of how much can the solitary confinement be completely. So if the rigorous imprisonment given is for 6 months, up to 6 months, it cannot be, the solitary confinement cannot be more than 1 month. If the rigorous imprisonment is between 6 months to 1 year, it cannot be more than 2 months. And if it's more than a year, the rigorous imprisonment, then also, like the first rule said, under no circumstances can it be more than 3 months, right? And these limits are the maximum limits, they're not the minimum limits. So the judge has to ensure that they do not cross the maximum limit. The judge can feel that no, just 2 days of solitary confinement is sufficient, then that's okay. But it cannot be more than these limits prescribed here. Okay. The second last punishment that we're going to talk about today is death penalty. I'm sure you've, in your constitution law classes, in your criminal law classes, you've dealt with this very elaborately. So I'm going to touch upon it very, very lightly. And I'm going to just tell you how the attitude towards death penalty has changed, right? It's given for the most heinous crimes now. It's given under section 4A of BNS, but the position was not same. So you have position before 1955, then 1955 an amendment comes, until 1973 that position says, and when 1973 CRPC came, position changed again, which continues with BNSS also and BNS also. Before 95, death penalty used to be the rule and life imprisonment used to be the exception, which is why the rule was very clear that in case if the offense says, if the punishment for the offense says that you can give that person imprisonment or death penalty, and if you're not giving death penalty, then you have to specify why are you not giving death penalty. So before 1955, that was the position. Amendment came in 1955. They said, you can give death penalty, you can give rigorous imprisonment. If you're giving death penalty also, no need to specify any reasons, reducing the burden of the judges. But then 1973, when the position changed, death penalty became the exception, right? And life imprisonment became the rule. That if a person has committed an action which is punished for an offense wherein you can give life imprisonment or death, you have to specify reasons if you are giving death penalty as to why are you giving death penalty. So you see a shift in the attitude. Initially, death penalty was the rule till 1955. After 1973, death penalty became the exception, right? Coming to the last segment of today's lecture, the community service provision. I'm sure whatever I'm going to tell you for this, that has already been discussed yesterday. It was told to you yesterday also that section 4F of the BNS is where this has been introduced. There is no clear definition in the BNS which talks about what is community service, but you find that under BNSS, right? In the explanation to Section 23 of BNSS, which says that what is community service. So it's basically when you're doing unpaid work for benefit of community as a way of reforming yourself, as a way of paying what you've done in terms of crime. And it can only be given for very less severe offenses and offenses which do not include any violence. There is a list that is given here of all the sections under which community service is given. The sections that were there in the IPC have now been similarly kept here in the BNS also. I've given you the sections of the BNS also. We'll quickly go through them and then we'll wind up the lecture. The first is, if there's public servant who's unlawfully engaging in trade, then that person can be given community service, right? If there is a court that is called upon an offender to appear, and if he is not appearing for that action, that because you did not appear when the court called, right? Your non-appearance against a proclamation, then you can be asked to do community service. Then if you are forcing, if you're compelling, or if you're not allowing the exercise of lawful power by trying to commit suicide against that, because for attempt to commit suicide, you will read this in your upcoming modules when we're talking about how suicide is now being treated under BNS and attempt to suicide is being treated. You will see that we don't treat it as an offense anymore, which is why when you try to use attempt to suicide to compel or restrain the exercise of lawful power, we give it as the punishment could be community service, right? And in all these provisions, community service is not the only punishment prescribed. It is given as one of the options to the judges that you can also give community service. That's also an option that the judge may have to give as a punishment. Then when a person has committed a theft who is a first-time offender, he has never committed theft before, he's never committed a crime, he's committing a theft and the value of the property is below 5,000, he has returned that property or he's returned the value somehow, then that person can be made to undergo community service and not any other punishment. Then if you're intoxicated, if you're creating a nuisance in a public property, if you're annoying someone, if you're harassing someone, then you can be made to do community service. And finally, if you are committing the offense of defamation, then one of the punishments could be community service. So that's all on the punishments that can be given under BNS. So thank you. If you have any doubts, you can ask right now, or if you want to think about it more, and if you want to reach out to me, feel free to do that. My email ID is given here. It's contact@ukritamlegal.in. You can write the email ID in your notebooks or wherever you want to write it, and then you can contact me later also. But if you have any doubts here, I'd love to hear that.
Ma'am, community service could be offered, ma'am, if we misuse the defamation law, ma'am.
We don't simply say misuse the defamation law, right? It's simple when you defame someone. There's no misuse of defamation law. It is as simple as if you are... Yes, please.
Ma'am, but in defaming, ma'am, we can claim damages and money. So,
of course, you can claim damages, but the point is that damages cannot be claimed in criminal law, right? So damages is a concept of civil law. If you want damages, you have to file a tort of defamation. You're understanding what I'm saying? The damages are not part of criminal law. If you want to claim damages for what you're saying, it has to be part of a civil suit. In criminal, if it's coming, so either the punishment, which is otherwise prescribed, imprisonment or fine, or as a judge, the judge can give community service also. Okay?
If we misuse this law, and if we misuse this defamation law, ma'am, if
they misuse this defamation law and if the victim wants compensation, he has to file a civil suit. If somebody is misusing the defamation law and the judge feels that he's misusing in a criminal case, then he can give either imprisonment or fine or community service. Okay?
Okay.
Yeah? Okay. Nitin, any other doubt before I go on to Sakshi's doubt? Any other doubt, Nitin?
No.
Okay. Okay. Sakshi has a doubt. Why is there inequality between male and female in death penalty? As some women are convicted of death penalty but is not executed. Sakshi, the reality is a majority of convictions that are overturned of death penalty are of males. Because the majority of people who are subjected to death penalty is males, not females, right? With females, there are a lot of mitigating factors that come. I'm sure when you read about death penalty in section 302, which will come in your upcoming modules also, there also you'll have an elaborate discussion. But just to mention here that with females, you have to have some factors into consideration also. For example, if she is pregnant or if she has a small child, then that factor comes into picture. If she is the only one who is going to be the person who's taking care of the family, in such considerations, because of such considerations, usually death penalty is either not awarded, or the conviction or the sentence of death penalty is overturned and converted to either life imprisonment or reckless imprisonment. But you will see that there is a huge disparity between the number of death penalties awarded to males versus females because of these factors. Have I been able to clear your doubt, Sakshi?
Yes, ma'am, it's clear.
For everyone else also, not just Sakshi, do you have a subject of criminology?
Not yet, ma'am. Actually, I'm a student of first year.
Okay. So when the others, if you have read criminology or when you will read criminology, for the ones who are yet to read it, you will read these theories. Criminology is about why people commit crime. And there you will come across a theory which says why women commit less crime as opposed to males. And that's a very interesting discussion. Anybody who's more interested to find out about why is there disparity, you should definitely go and read about these theories. Any other doubt?
Ma'am, I have a doubt.
Yes. Yes.
Ma'am, as in the Bilkis Bano case, the convicts were released on the basis of good behavior during their period of punishment. Is it anyways or somehow similar to the community service that has been introduced in
No,
BNS?
no,
Or is it something else?
no. So when a person is released, he's free to go. Again, the Bilkis Bano, the release of these convicts is a very controversial matter. It is still,
Yes.
it's still debatable. It's still pending for review. So there's no point in commenting on what happened was right or wrong, but it's not community service, because when you are released, you are released. You're free to go. Community service, you're not free to go. There will be an inspector who will constantly check whether you're doing your work or not. So you're not free. You have to report to that instructor that this is what I've done. Okay.
Okay, ma'am. Thank you.
Sorry, Dipta, was I able to clear your doubt?
Yes, ma'am.
Yeah. Okay. And anyone else?
Ma'am, is there any special reason to introduce community services?
Yes, there was a special, because see, we have to understand that there are a lot of times this community service that has been introduced, we were, as legal scholars, as academicians, as people in law, we were hoping that it would have been introduced for more number of offenses, right? So this concept is a concept of reformation, that you want to work on reformation for people who have committed very less serious crimes, right? Instead of, let's say, somebody who is intoxicated and creates a ruckus in a society, there's no point sending him behind bars, right? Because there's no point in sending that, because there's no assurance that he will leave his habits or he will not do that again. But a community service is a lesser punishment. At the same time, it's to make him realize that what you did was wrong. Because when he'll do work, unpaid work, which is, even if it's not going to benefit him, it's going to benefit the society. So he'll realize that, next time when he's doing something, he'll realize that, I didn't have to just stay in the jail for, let's say, one day. I had to do 3 months of community service. So that took a lot of effort from my end. So that's ensuring reformation as well as, satisfaction to the society. Sakshi, is the doubt clear or any other doubt?
No, ma'am. Thank you so much.
Okay.
It's clear.
Anyone else? Anyone else, people?
Ma'am, basically, ma'am, community service is unpaid labor.
Yes.
Okay.
Community service is unpaid labor. You don't get paid for it.
I'm not shelter, not food.
Food and so you have to understand that when you're saying a community service, you are not being sent to a jail. Jail is probably where you would look for a food and shelter or free of cost, right? But that's not happening. That's why community service is being looked as a future alternative for all offenses in which simple imprisonment is given, right? That rather than sending to jail, when you do nothing, you probably can do, let's say, 5 months of community service or 6 months of community service, so that the society will also benefit. It will not be an economic burden to the society also, and the person will have some sense of deterrence. Okay, Nitin, was I able to clear your doubt?
Yes.
Any other person, any other doubt? No? If you have any doubts in the future also, you have my email ID. Feel free to reach out. Just drop in a mail saying that we were part of this seminar and we were part of this module wherein you had told this and this is the doubt that we had. That's all. And I'll respond.
I
Okay, if
think
there
all
is
the
any
doubts
doubt.
are over, and I request all the students to note down the email ID. And I'll be sending that email ID in the group. If you have any queries or any doubt, you can contact ma'am directly on her email ID. I request Sujata to please close the session.
Sure, sir. On behalf of CPJ College of Higher Studies and School of Law, we extend our heartfelt gratitude to today's speaker, Mrs. Nidhi Sinha, for the delightful session. Your knowledge have truly enriched our understanding and made a significant impact, ma'am. Thank you so much for your valuable time and contribution. Thank you.
Thank you so much. I thoroughly enjoyed interacting with you people. I am very happy that this was an interactive audience. You guys participated so much. I'm very happy with that.
And though the cameras were not on, but students were interacting and they were.
I'm sure they were.
Thank you
I
so
hope
much.
that the students learned something and
Yeah.
I mean, I hope that they enjoyed this session as much as I did.
Ma'am, they surely will give their reviews on this. We will be sending a link for the review and we'll be showing and we'll be sending you the same.
Oh, that's very nice. Thank you so much.
Thank you so much, ma'am.
Yeah. We can leave the session then.
Sure, ma'am. Sure, ma'am. I'm just closing the session.
All right. Thank you so much. Thank you so much, everyone. Shweta ma'am, thank you so much for this opportunity. Okay. Thank you, everyone.
Thank you, ma'am.